Hi, I'm Jamie Johnson of the Johnson Law Firm, where we do estate planning and probate, and we do it well. Today I'd like to talk to you about, do I need to have more than a will to make sure my loved ones are taken care of? Now the short answer to that is, maybe. It depends on your personal situation, and that's why it's important to sit down with an estate planning attorney and go over your situation so that way they can best advise you how to handle it. If you have a rather simple estate and you're just leaving everything to your spouse, then a will would be sufficient. These are what we call the typical I love you wills. Honey, I love you. We spend a lifetime together accumulating all these assets. I know you'll take care of the children. I leave everything to you. That is the traditional will between spouses in a nuclear family. However, if you have a blended family from a second marriage, then a will might not be the best option for you. In fact, a trust might be the best option for you. Now, also in terms of wills, if you have adult children who are happily married and they have no other real issues, they don't have any drug or alcohol issues, they don't have any issues with creditors, or they don't run their own business, they're regular W-2 employees, then a will should be fine. However, if your adult children are in a rocky marriage, or you want to make sure that girl that your son married never touches a dime of the money you've spent collecting and building during your lifetime, or you're not quite sure about that guy your daughter married, then a trust would actually be best for that situation. Also, if your children have started a business and there's a risk of having creditors, then a trust would also be best, because through a trust you can make sure that your assets are there to provide for your children, that they'll inherit it, but they would be asset protected, which means the creditors would never be able to touch the inheritance that you've left for your children. However, if they inherit it outright through the will, it's not asset protected, and if their business were to go under, like a pandemic, which we recently have had, you never know with a business what's going to cause the business to fail. However, with the asset protected inheritance, even though their business might go under, the creditors will never be able to touch that inheritance. That inheritance can be used to help your child out, to help their family out. The more common issues between wills versus trusts involves minor children. A will is required if you have minor children, because that's where you typically name the guardians for your child. If something were to happen to you and your spouse, if you were to be killed in a car accident while either on a family trip to Disneyland or on a weekend trip to BJ's or Costco, you never know when that catastrophic accident might happen. If you have minor children, you need to name guardians for those children. Otherwise, you risk your family and your spouse's family fighting tooth and nail over who gets the children. And that's the last thing you want to put your children through after they've already suffered the loss of you and your spouse. So name guardians in a will. However, if you leave your assets in a will to your children and you don't protect it through a testamentary trust, then when your kids turn 18, they're going to get the money. If you want to screw a child up, give them money at 18. If you really want to screw a child up, give them a bunch of money at 21. But if you leave your money through a will in a testamentary trust, then that will be court supervised, which can be rather expensive and cumbersome for whoever's the guardians of your children or whoever's managing that testamentary trust. The best option is, if you have any kind of significant assets or life insurance that you're leaving for your children, then the best option is to create a trust. You can name the trust as the beneficiary of your life insurance. You can make sure that all your assets from your will go into the trust instead of going to your children. That way, whoever you name as the trustee can have greater control over how to use the assets for the benefit of your children. And you can set age restrictions on it from anywhere from 21, more commonly 22, 25, or 30, to make sure that that money's there to provide for your children as they're growing up, pay for Little League, braces, band, whatever they're into as they're growing up. You can buy them a reasonable car when they're 16, so that way your child's not a burden on the guardian that you left them to in terms of a financial burden. And also you can make sure that college money will be there. And that money, after they've paid for college and raised them, any money that's left over will not just be blasted through and spent when they turn 22 and graduate from college, but can be held to help them as a down payment for their house. All that is power you can grant to the trustee through a trust. That power is not there through a will. So if you have young children, I highly recommend a trust, and that you name the trust as the beneficiary of your life insurance and of your will. If you have older children, then a trust can also be beneficial in terms of avoiding the time and cost of probate, but also to protect your child from the possibility of divorce. Because if your child inherits money from you and they in any way commingle or mix that money in with the family money, which they will be pressured to do by their spouse, then all of that inheritance money becomes part of the divorce and can get really messy. A trust is a simple and easy way to cut all that out, avoid it, keep it separated, and make sure that your child is protected. If you have any questions about do I need to make a will and how will it affect me, then reach out to the Johnson Law Firm. We're happy to answer those questions for you.